to do a draw after the big issues, but it will depend on how all of us are able to participate and then get things running for us, okay? Let's make Cash Money Cookie, who is convalescing or recovery at home, very happy, so that she'll come and continue her good work. But in the meantime, please make sure that as many times as possible, you are able to take part in this mega jackpot. And then also, when you do that, please know that we're always happy that you join. But in the meantime, a number of you have joined us this morning. We're just looking at the following the release into the public domain of the judgment by the Supreme Court on that vacated seat, so to speak, ruling by the Speaker and what the implications there are. And right now we have the reasons that have been adduced by the judges in that 5-2 ruling, the majority 5 and then the minority 2. And subsequently, when you take a read of it, very interesting there, a number of, well, things that have been noticed so far by those who have studied the law. Let me say good morning to you, Michael Che. Good morning. You're joining us from the UK. Great guy. Kwesi Mensah from New York. Thank you for joining. Michael Chase in the UK. Barnabas, you've joined us as well. Amidou Bright, Ibrahim, Awudu, I see you. And then also Don Wazi, Zilis Dwayne. You said I shouldn't call it Zilis Dwayne. Zilis Dwayne from the UK. Good morning, everyone. I hope they're well. And Kweku Aaron joining us from the Eastern region. I have lawyer Pia Dankwa, who is in the studio. Good morning to you.
Good morning.
And then also lawyer Amaliba. He goes by the first name Abraham, father of many nations. How are you?
I'm good. I'm okay. I'm fine.
And then lawyer Kwame Jantwa of Ajantwa. How are you?
I'm fine. I'm happy the good Lord has
given us another day.
No, given me another year.
Today's your birthday.
It's my birthday tomorrow.
Tomorrow.
Yes.
Happy birthday to you.
It's my 67th birthday tomorrow.
You'll be
67.
You?
Yes.
Please give him a close-up, let me see.
Why?
Fanta, you look handsome.
God is good.
Who do you resemble? Is it your father or your mom?
Both.
Both. The very beautiful and handsome parents you have.
So your father and mother were twins?
No, they weren't twins. They got together.
So, Nanaya Chimpinjantwa has a fair skin. It's in the family.
My father is fair.
Your father is fair.
Yes.
Where did you pass? Because you
My mother.
Very dark. Okay.
But you haven't seen me, what do you call it?
Oh, okay. So beneath. So the devil is in the detail. Today is a Friday, so please, for those who have joined us, please share the stream. I already see Kingsley Ofori. Please, all of you, *439#. Today, we're doing a mega jackpot. Over the last 4 weeks, we've been giving 50,000 Ghana cedis out. And today, too, we want to replicate same. We can only do same if you are able to increase the number of tickets and replicate your numbers as many times, tens of times, in the baskets. It is an electronic basket. It's very electronic, very imaginary. So *439. Choose option 8. Please choose option 8. That's the mega jackpot, MG jackpot. And I want to make sure that I do the draw as many times as I can at the end of the show. All right? So please, make sure you stay with us. I see a number of you as well. So, Lawyer Pia Dankwa, you've read the ruling of perused it. Let me... Okay, so we'll just take you through the highlights. And it says, well, they hold that upon a true and proper interpretation of Article 97(1)(g), the legal element of that provision can be formulated as an MP must vacate his seat if he leaves the party under which he was elected to join another party or goes independent and seeks to remain in Parliament under their new political status. Similarly, with regards to H, it says the proper legal element can be formulated as an independent MP must vacate his seat if he joins a political party in Parliament and seeks to remain in Parliament under his new political status. I don't know whether Isiama also falls in this, but maybe for a future as well. Because if you look at the judgment, it takes cognizance of why those who have elected these individuals also need to be served in the current term of the parliament that the MP is serving. So let me
take this opportunity to wish your lovely viewers a good morning. Wish my big brother Jantua happy birthday in advance. Hopefully tomorrow we can have a proper celebration. Always a pleasure to be in the company of my learned senior. Amaliba, I was 1 year his junior in the law school. So.
Oh, is that so?
Yeah, I was
Only 1 year.
Only 1 year. He was my senior from as in Legon, and then we went to law school.
I think 1 year is small.
It's not small.
So what should I say?
Yeah.
What should I say?
You are his senior. I didn't know that.
Amaliba is 1 year my senior.
Because I call you Akwadanyame because everybody here has been your senior for most of the times that we've introduced you together, or maybe we've made inferences. But please go ahead.
So let me state categorically that we all understand that it's the duty of the courts to say what the law is. And when matters that borders on interpretation arises, essentially what the court is doing is to give a clarification on what the law is concerning the constitutional provision where there is a confusion. And so it's essentially that's what the Supreme Court did. What's it called? Was it on Tuesday? On Tuesday, yes. But having said that, I think I need to start by stating my position. My position is that I disagree vehemently with the decision of the Supreme Court.
You disagree vehemently?
Vehemently with, and I stand on all forces with the dissenting view. And when you read the ruling of the court, you realize that there were two broad issues. As in there were a number of issues, but there were two broad issues. One, the first issue borders on on the jurisdiction, whether or not the jurisdiction of the Supreme Court had been properly invoked.
Yes.
And on that decision, it was 5-2. It was 5-2. On the other issues, as in on whether on the interpretation to be given to what's called Article 97 1G, and then in granting the reliefs, that one on the proper interpretation of Article 97 the members have not vacated their seats. On that, I think it was unanimous because the two judges, as in Tanko and Lovelace, did not make a pronouncement on those issues. I think we all need to be clear on that. Now, I think when you read the decision in its entirety, there's a fundamental confusion in the decision of the majority. Now, Article 20 on page 24, they stated that one of their reasons for why they felt they had jurisdiction to even detain the matter, in spite of the clear terms of Article 99. Now, with your permission, let me read.
Please do.
Now, on page 24, it says that, but more important is the need to emphasize that the disputing issue arises solely from what the proper interpretation and application of Article 97 1G(h) is to the fate of the affected MPs, filing nominations to contest the next election as independents or on tickets of political parties that they do not currently represent. The suit essentially hinges on the pure question of law, specifically the proper construction of Article 97 1G and H to establish the legal threshold for triggering its provision, without delving into factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter of interpretation of Article 2.1 and Article 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. It is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. You understand? So, my understanding of this is the Supreme Court's job is to simply interpret the meaning of the provision under dispute, and then where they have made such interpretation, it is for the High Court then to make a determination. Now, when you go to now, having beautifully laid down this principle, they then proceeded to give their interpretation of the said of the said article. Now, and indeed, you find their interpretation even in their holding. And so when you go to page 35, where they said, in the end, we reiterate that on the true and proper interpretation, Article 97(1)G only requires that an MP must vacate their seat if they leave their party under which they were elected to join another party or become independent and seek to remain in parliament under their new political status. You understand? Now, I agree with the interpretation they give. They give. I think it's an interpretation that all of us here in our submissions on this issue have alluded to. We have all said that under a proper interpretation of Article 97, you must vacate your seat if you leave the party under whose ticket you entered parliament. Now the question then is, in the determination of whether or not you have vacated your seat under the provision of 97(1)G, you need to make a determination whether or not the member, the MP, whether or not they have left their party. That determination needs to be made. The determination, you need to make it so then it must become an issue. That having interpreted the 97(1)G to hold that if you leave your party, then you must vacate your seat. Then the question will become, so the three MPs who have left their who have attempted or have given indication that they are going to contest the election as independent, have they left their parties? Whether or not they have left their parties by filing to contest as independent, that question is not a question of law. That is a question of fact. And the question is whether or not the Supreme Court has the jurisdiction to answer that question. It's a question of fact. Whether or not you have left, you see, the question whether or not you're a member of your party is a question of fact. It's a question that the 1992 Constitution won't answer, because that will depend on the constitution of the political party. And so that's a question of fact. So in an ordinary case where you claim that somebody has left the party in court, you'll be expected to give evidence. And the evidence to that question will be to present the constitution of that party. You understand? And that's why the constitution, in this wisdom, says that whenever there is a question as to whether or not a seat has is vacant, having regard to the 97, says that it's the High Court that's the proper forum to determine that question. You understand? Is that because the Supreme Court do not have the jurisdiction to determine on that issue of fact? The original jurisdiction, so far as that question is concerned, lies with the High Court. But what did they do? Having interpreted, they then went further to make a determination whether or not the MPs concerned have left their parties or not. And then they came to that erroneous conclusion that by they filing their nominations only gave an intention of what they intended to do in the next parliament without addressing the issue whether or not as of today they have left their parties. And that is the confusion in the judgment of the court. Because at the end of the day, like I'm saying, the question whether or not a member has left his party is a question of fact. Now, and so, if they had taken the position of the dissenting view, you understand, and restricted themselves to the powers granted them under Article 2 and Article 130, simply interpret. You understand? Simply interpret. You understand? Because, like I'm saying, they do not have the jurisdiction to go into the factual issues. And factual issues, then you will be calling for evidence. You understand? And that jurisdiction lies with the High Court. And so right now, what they've done is that they've given a judgment which portends serious confusion for our democracy. Because you know what is going to happen because of this?
What do you think will be the implication?
Under MPP's constitution, it says that if you contest against a candidate sponsored by their party, or if you support any candidate against the candidate sponsored by party, you automatically cease to be a member of the party. Indeed, we saw what happened to Hossein Adoye, to Nana Ohintu. And so now this ruling is saying, this judgment is effectively saying that if you contest against what's called a candidate sponsored by the MPP, and let's say you are an MPP member
or
of
any other party,
even though per their constitution you cease to be a member of their party, you still be you still remain in parliament as if you were an MPP member. Is that not?
Is it not true that when you look at the judgment, the Supreme Court, in its considered view, make considerations for the rights of the constituents who elected those individuals? That for them, for the remaining period for which these members should be in parliament, could, if they vacate or are made to vacate their seat, be deprived of a member of parliament. And it's very important.
The Supreme Court itself is saying, per their interpretation, they themselves are saying that in spite of all the reasons they are giving, if you leave, because right now, the law in Ghana right now is that per the Supreme Court decision, you don't even need to quote 971. Per the Supreme Court ruling decision, the position of the law is that if you leave the party of which you were a member, on whose secretary you entered parliament, if you leave that party, in fact, Esiedu, Justice, his lordship, Justice Esiedu, even went further to say that, per his understanding, if you resign from your party, it doesn't matter whether you are going to deprive your constituents of their representation, you automatically cease to be an MP. That is what Justice Esiedu said in this judgment. You understand? So if Justice Esiedu said that if you resign, you understand? Is that not, whether or not you have resigned, is that not a matter of fact? Because the Constitution does not deal with issues of where you've resigned from your party. It deals with the issue of where you have resigned from parliament. There are two different issues. If you resign from your party, you understand, it's a question of fact, not a question of law. You understand? And whether or not a resignation from your party will cause you to leave your party falls within the ambit of the reasons the party have given under their constitutions for what action you undertake will make you leave their party. You understand? And that's why I'm saying that immediately the Supreme Court, even though having held that they had jurisdiction to entertain this matter, went ahead to then give clarification to the extent of their jurisdiction. Okay. As against 99, please let me conclude on this. You understand? Because they made it clear that when it comes to interpretation, they have the jurisdiction, irrespective of Article 90, what Article 99 is saying. However, they haven't given the interpretation, it then behoves on the High Court to then apply those interpretations. So having given this clear law in their own, what authority did they then have to then delve into factual issues? Because the question is whether or not the MP has left his party. It's not a question of law. It's a question of fact. And it's a question that is only the High Court that has the power, the jurisdiction to answer.
All right. Lawyer Amakwabedu also has joined us. Good morning to you. How are you?
Good morning.
So that said...
I just joined you.
Yeah. So no. So, Lawyer Maliba, that said, does it...
All I can say for now is happy birthday in advance.
Oh, you were listening?
I watch everything before I get here. Happy birthday in advance.
Thank you.
And it's not the only Akwara Nyame here. It's not the only Akwara Nyame here.
You know, I referred to you, that's why. I referred to you.
And good morning to my learned friend, Mr. Maliba, and yourself. For now.
Yes.
Lawyer Maliba, having gone by the submission that has been made, and then also those out there in the public domain, with the Supreme Court saying that it is clothed with the jurisdiction to hear the substantive matter, then if there's the need to invoke the powers of the High Court, as stipulated in Article 99, in relation to a member of Parliament having vacated his or her seat, then it means that that action could be taken henceforth. Is that not the case?
I don't get the import of your question. Can you rephrase?
So basically, in this judgment, they say that there is no determination that if you are going to contest the next election on the ticket of another party, or as an independent onto another party, or a party to an independent candidate in the next election, you cannot be seen to be vacating your seat in the current parliament you're serving.
Yeah.
And I'm saying, in order for that action to be invoked, in relation to Article 99, who has that power to do that? Who can go to the High Court and say that this gentleman has taken this action. As a result of that, per Article 99, I want you as a High Court to do what is needful.
So that's how confusing the Supreme Court ruling is. The more I read the judgment, the more I became embarrassed. What I noticed is that the Supreme Court sought to rewrite the Constitution under the guise of interpretation. And they have no such jurisdiction. They have no jurisdiction to rewrite the Constitution as they purported to have done the last time that this matter was in court, or per the ruling. Why? The Supreme Court, in my view, acted unconstitutionally.
How can it?
It can. Because the Supreme Court itself is under the Constitution. And the Supreme Court cannot give an interpretation which is not born out of the Constitution. So when the Supreme Court gives an interpretation that is not born out of the Constitution, that is unconstitutional. And I've heard the Attorney General say that the law is what the Supreme Court says it is. You heard him say that. And I cringed. The law is what the Supreme Court says it is if it is born out or is envisaged by the Constitution. The Supreme Court is not higher than the Constitution. So today, there is no way, if the judges in the Supreme Court, all of them sleep and wake up and say that we want to make a ruling that all men in Ghana are women and women in Ghana are men. And they agree at their conclave, and then interpret the Constitution, a portion of it or a provision of it, and say, so it is. That cannot happen. In other words, the Supreme Court cannot on its own decide that, even though the words are clear, who will say it is like this? I don't know whether you are following me. The Supreme Court has no such power. They have no such power. The Supreme Court, I've said time with our number, and people, you see, people, we have made it look, and the Attorney General has also helped in that. We have made it look like the Supreme Court can say what it wants. Never. The Supreme Court itself is a creation of this Constitution, and so it's under it. First and foremost, was there even an issue of interpretation? There wasn't. The words are very clear. But they went ahead to interpret and said that the fact that you pick a nomination form does not mean that you are joining a political party. And I asked myself, you are joining a political party different from the vehicle that brought you in. And I asked myself, can I, who is known to be an NDC, just walk into the MPP constituency office and pick a form and say, I'm going to contest for MPP candidate? Can I just do that? Before you pick the form, you must have first joined them. I'm saying it again. Before you pick a form and even go for nomination, you must have first satisfied the conditions of being a member of the party before you can pick the form. So, let's take the speaker, the deputy speaker. Isiama was independent.
Now going
for party.
Party, yes.
What it simply means is that the MPP have satisfied themselves that he's now their member. That's how come he can pick a form. And what is the Supreme Court saying? That even when you file your nomination, it doesn't mean that you have crossed carpet. How is that possible? How is that possible? This is a program, ordinary Ghanaians are listening. So me, I don't like quoting article this, article this.
You like to go ordinary?
Ordinary.
Okay. So let me just refer you then. Because despite the existence of the provisions in the MPP's constitution, which makes it automatic and very clear that if you take certain actions, pursuant to, then you forfeit your membership, thereby meaning that ideally, you shouldn't be representing the same party in parliament. When you come to the national constitution, in this judgment, the Supreme Court says, in its own estimation, that there's no doubt that rival meanings have been placed on the provisions of Article 97, 1G and H of the 1992 Constitution by the Speaker's statement on the floor of Parliament, and the plaintiff thereby displacing all lingering doubts that this is a proper case for invoking the original interpretative jurisdiction of the Supreme Court as so established. That clearly means that in the mind of the Supreme Court, they feel this is in their domain.
I disagree with them because we all did interpretation at the law school, including them. You give words their ordinary meaning first. Give words their ordinary meaning first. The meaning on the street of Accra. Give those words that meaning first. And if it leads to absurdity, then you can now bring in a secondary meaning. Didn't we do all this in the law school? Give these words that you have read, give them their ordinary meanings, and let's see whether there will be absurdity.
Shadrach, put Article 97.
You put them, read it.
Put them on the screen so that everybody will see.
And we see whether it would lead to absurdity. You don't just jump into the middle and then start saying that you want to interpret. For what reason? Those words, and I said, and Justice Tanko has also reiterated that point, this judgment will not stand the test of time. And you know what they have done? They have effectively struck down Article 97. Article 97, the question is, when will it ever be relevant the way they have done it? When will we ever, when will we ever say that per Article 97, a minister, a member of parliament has crossed carpet? They have effectively done away with it. They've made it useless.
They've rather given it a meaning they deem fit.
And I'm saying that let's follow their meaning. When we follow their meaning, when will this article ever be invoked? It will never happen. It will never happen. See, I was here the last time and I asked the question, what did the speaker do for the writ to be filed against him? And it is true. The majority side admitted that the writ was filed on the 15th. Speaker's action was on the 17th. So the writ preceded the speaker's action. So what are you calling on the speaker? What are you calling on Parliament, on Supreme Court to do? There was nothing before the Supreme Court.
And what was the reason for the writ on the 15th?
Because what Afenyo Maki is seeking to say is that the speaker's pronouncement must be declared null and void. On the 15th, the speaker didn't make any pronouncement for God's sake.
So you're saying what? He was only acting on speculation on a campaign platform?
Supreme Court doesn't take speculations.
So what are you saying?
I'm saying that there was no course of action. A course of action has not arisen. See how they try to meander their way out of it. There was no course of action. Now, one would have expected that now that the speaker had made a pronouncement on the 17th, per the Supreme Court rules, you can amend your writ. One would have expected them to amend their writ to reflect the complaint they have. They didn't amend their writ. So what was the Supreme Court going to determine when Speaker had not yet, as it were, spoken? That's another flaw. Another flaw. You see? So there are a lot of flaws in this judgment, and it is not helpful to our democracy. And I tend to agree with my senior Judge Shikata that coup d'etats are not only carried out by men in uniform, but they can also be carried out by men and women in wigs and gowns.
Alice School.
You know? So, You look at all these things, then you begin to think that the building blocks of our democracy are being chipped away gradually, and at the end of the day, we will not have a democracy. This is not how I expected the Supreme Court to conduct itself. And I agree with Justice Tanko that a future Supreme Court, differently composed, would overturn this.
I see. Very interesting. Lawyer Makobodo, at the end of the day, practical lessons that we can all learn from this, and then making those deductions from this judgment also means that we've come to a position where a member of parliament could take an action to stand on the tickets of another party or as an independent candidate whilst in the present parliament, and will be made to represent his party irrespective of whether he's competing against them or not, or whether his party's own constitution goes against his actions he's taking. Is that right?
Thank you very much, and thank you to your viewers. Good morning to your viewers and listeners. I tend to want to pick something from what my brother Maliba said, which is to simplify the issues for our viewers and listeners. And drawing from that, I want to latch onto this analogy that if you're employed and you serve your letter of resignation to take effect 3 months from that time, does it take effect from then, there and then, that you served your resignation? It doesn't. Obviously, your boss will be knowing that this person is not something we should be planning ahead with.
I don't understand. When it's stated in the code of conduct that when I take an action, I forfeit my employment status?
Yes, but in your employment status, it is in lieu of your salary, isn't it? So you normally have to give them ample time for which it will take effect. If you don't do so, you miss your salary. Is that not so? And you're supposed to give them that period for them to also look for replacement. Is that not so? So you always give them prior notice that from this date onwards, I cease to be.
What if it's an action that's taken that amounts to you being summarily dismissed?
That's a different thing.
No, it cannot be. Because in the MPP constitution, there's an automatic dismissal, so to speak. If we have to say this
is... I'm giving you an analogy.
If we have to say your same analogy is coterminous...
Yeah, but so in that analogy, is it the case that what they did was to commence there and then? And my brother gave an example of Hobson Adoye and co. What these people did was to say that in this coming election, we are standing on either going independent or standing on this ticket.
That's what we're talking about.
Exactly. It doesn't mean that they were saying that here and now. I have stopped. I'm no more a member of parliament. That's not what they said, is it?
Are you saying?
And I'm giving another an analogy.
Let
me give you another analogy.
Are you saying that Alan Tremantin...
No, don't do that. Don't do that.
You
allow everyone to talk.
Yes.
So let me talk.
No, okay, so...
Let me talk.
Are you saying that...
Let me talk. I haven't finished.
No, lawyer...
Don't do this. Don't do this. Don't do it. Don't do it.
Let me make this...
No. Don't do it, please. This is the only time I'm getting angry on this show. Don't do it.
That's fine. Go ahead.
You allow everyone to make their point. You won't allow me to
go ahead.
Why am I here?
Go ahead.
Please. In the same version, when you file for a divorce, that is formal, going to court. Does that divorce, because you have served it on your husband or wife, take effect from that moment in time? Would you not allow the court to go through the due process, then the court to pronounce on that? Is that not what happens? Why is it that for political purposes, we are now reading other meanings into this to say that now the Supreme Court judgment, we are ashamed of it, copious legal principles being alluded to here. We are not saying we are even ashamed of it. And that there's a coup d'etat that can be done by men in suit. The first coup d'etat in this instance that was done by another man in suit in another house, which is Parliament. And that we were happy with that.
What did they do?
For you take a decision that changes the how Parliament is constituted, the business that could be done, and the Supreme Court takes steps to solve that problem. We can decide not to be happy with that or agree with that. Everyone is allowed to do that. In fact, when we go back to our classrooms, it is in discussions, commentaries, articles, so on and so forth, that has been written on a judgment like this, that we will teach. And there's no denial of the fact that there are dissenting views or minority decisions that eventually becomes majority decisions. Eventually. Lord Justice Denning in UK kept it. It was so much so that he was dissenting. Eventually, his position now becomes what is adopted by the same court. Eventually, differently constituted years later. So there's no denying of that fact. Okay? But for now, this decision simplifies the issues, solves the problems, and we can now go further. We cannot say that the persons who said that in the coming election, I am going to stand on this ticket, has definitely now become an MP of that party. The people haven't even exercised their vote yet. Is it automatic that the moment you now say I'm crossing over to this side, you are now an MP in this current Parliament? And that was the main issue. So once we are breaking it down, let's break it down so everyone to understand. Okay, that we're dealing with the 8th Parliament. The court was of the view that these individuals in the 8th Parliament are saying that we belong here. They haven't resigned. They're saying that in the coming election, we will stand differently. It doesn't even make them an MP in the coming Parliament, because the coming Parliament doesn't even exist. They still have to submit themselves to the constituency for the constituency to have a say. There are instances where people will even file their nomination in the same party and the constituency will change it. There are several people who have lost elections and it's been changed. You see, so let's not...
Can I ask a question now? Can I ask a question?
Yeah, even as if now I have become...
Can I ask a question?
Ask a question, sorry for flying.
So, respectfully, when we have the wording, in Article 97(1), a member of Parliament shall vacate his seat in Parliament. Then you go to G, it says, if he leaves the party of which he was a member. So, the first instance you were, the Constitution said, if you were, if he vacates from a party where he was, and subsequently decides to join another party or seeks to remain in Parliament as an independent, what do you think the framers of the Constitution were alluding to? Were they talking about a future Parliament or a current Parliament?
Okay.
Were they thinking the member of Parliament was already or still a member of his party, even though they made reference was a member of at the time of his election?
Okay, so thank you again. Let's look at Article 93 to begin with. 93 says that there shall be a parliament in Ghana, which shall consist of not less than 140 elected members. 2, subject to the provisions of this constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this constitution. Now, so it's not that another view which has been trumpeted that they are masters of their own and whatnot. Parliamentary power, which is vested in Parliament, has to be exercised subject to the provisions of this constitution. Now let's go into the question you gave. A member of Parliament shall vacate his seat. That means that he shall vacate his seat. It's not that someone has to pronounce on whether he should vacate his seat or not. If that is supposed to happen, that power now goes to Article 99, where a court, public constituted, will be a high court, based on the fact, will now pronounce that that seat has become vacant. Now, if he crosses over, and that's the whole issue. You see, this was put in primarily, or to a very large extent, under Parliament in Nkrumah's time and in Dr. Liman's time. All right, where you have voted for, you enter, and then you cross the days. That's why you say crossing. You see, you cross the days. The days is what the speaker comes when he comes and he follows that and is put there. Then Parliament is now in session. Then you cross the days. Then you have crossed carpet. Okay. Now, because he himself doesn't see what he has done as having crossed carpet, then he did not vacate his seat. It is futuristic. So, if you remember, and there's a case in court. So when you say that the Supreme Court has not pronounced on this, there's a case in the High Court filed by my good friend Samuel Kwakwado. I don't know whether he's going to continue with the case or not, but it's in the High Court. All right. If they feel that by their act they have vacated, the court will pronounce on that. But for the Supreme Court, you see, a lot of decisions and authorities stated in it says that they must bring finality to a matter before them. They are allowed to take judicial notice of events. Their main purpose in this, because it's a constitutional interpretation, is to bring finality to a matter. We are saying by the judgment, okay, their lordships have said by the judgment, 5-2, that the actions they took are futuristic, and that you cross to the other side, okay, in a particular parliament. When they have said that, they haven't said that they have crossed here and now. They are saying that they are crossing in the parliament which is about to come, and that is even hinged on whether or not they will be voted for. And I've met all the parliamentarians. All of them are super confident that they'll be voted for. So fine. And you need that so that you can project this confidence to your electorate. It is for your electorate to decide whether we are sending you back. If you are sending you back, this constituency, all right, majority of us belong to either NDC or MPP. Okay. So if you are sending you back to represent us, and you are now speaking with this voice, when we want you to speak with that voice, are we sending you back? That lies with the constituency. Okay.
So does it mean that the MPP, in putting that in their constitution, and even the actions taken by Professor Aaron Michael Quay, were all in error?
You see, I've already commented on Professor Michael Quay's issue. So all right? I've already commented on that. I'm saying that at that time, their standing orders gave him the power to do that.
What about the
renewed standing orders does not allow the speaker to do that. Okay. Now, the MPP are still standing together with at least Cynthia Morrison in a public engagement by the majority leader. Did you not see her standing next to him? Is it not?
Does the MPP have a candidate in the constituency where she is going independent?
If she says she's going independent, all right.
It's not she said, so there's notice of poll.
Precisely. Okay. If that's the case.
And I'm asking you, you are a key member, you are part of the legal committee.
Directorate, exactly.
Directorate.
Yes.
Does the MPP have a candidate in the next election to be convened on December 7, for which we already have notice of polls being issued by the Electoral Commission for the same constituency, Cynthia Morrison, who is the current MP, but going independent in that election?
Right. So, your question purports to say that we should take a step.
No.
I
asked you. My question is about a candidate.
Precisely. But your question purports to state that we should definitely take a step we took against the current second deputy speaker and what are your guys' names, please? Hope Sinadoye and the publicity.
For all of us are part. All of us
Get
are
out of here. Get out of here.
Get out of here.
Get out of here. You know, he's my very good friend.
Let me give you lawyer.
You see, and
You didn't answer my question, so I suppose that you're not interested.
I'm answering that question. Okay.
It was a very
exactly. So I'm answering that question.
It was a very specific
yes,
question.
I'm answering that question.
Does the MPP have a candidate
you
in
seem
the?
to say that we did not take that step.
I
all right?
said that.
Okay. Then I'm informing you.
Please listen to my question again.
We, as a party, have not taken that step against Cynthia Morrison and co. We are still engaging them.
No.
And so
you answered my question. You haven't answered my question.
In the decision
does the MPP have
Professor
a candidate?
In the decision that
does the MPP have a
Professor
candidate?
Took,
okay.
There was a letter from the party to him that this person is no longer a member of our party. That has not happened here.
Thank you. Thank you. That's a great lawyer. Again, does the MPP have a candidate in the constituency?
I have sold you the answer.
All right. Well, come down to so there's an interesting message that comes from Ansar, and Ansar says, I have a comment. By the Supreme Court ruling, does it mean a sitting MPP MP can go round and campaign against Dr. Mahmoud Bawumia, and then the MPP, and then the MPP's candidate, and still insist that he or she is an MPP member, and an MPP will have no right to punish the person or vote against the person, or get angry for campaigning against the party? Amid this message, what do you? How do we? How? No. But you refuse to answer.
Have a right. As my good friend was giving his commentary, what the person was saying went through my mind. But let me ask a question. Is there no implied intention by the person's action? And is implied intention not considered by courts and even within the Constitution? And when you look at courts, in considering implied intention, they interpret ambiguous provisions, addressing constitutional gaps or silences. Is that not silent? Silences? Resolving conflicts between provisions, and ensuring consistency with constitutional values. There is an implied intention by the individual. So let me ask, from the, what you call it you just read, if my good friend who is MPP is in Parliament and he decides with this particular sitting, he decides and announces to the whole world, I no more believe in the tenets of the MPP I represent in Parliament. In fact, I don't think some of the things they do is even right. So in the next Parliament, I'm going to another political party. What do you think the MPP will do? According to their own constitution.
Instead, they reserve the right to take an action.
Would they not say, the man, he doesn't believe in us anymore. He's not with us anymore. He's deciding to go to another party. So what is he doing here? Would they not write a letter to the speaker, according to their constitution, that the man is no more a member of our party? Will he not have crossed carpet then? Look, where I stand, I stand with the judges who dissented. Why do I say that? I feel the Supreme Court, yes, has the right to interpret any ambiguity or unclearness where the Constitution is concerned. Once you do that, especially in this case, and I've heard the MPP people talk about 99, the Supreme Court should have redirected the case back to 99.
To the High Court.
To be able to determine whether the individuals had crossed carpet, because that's what the Constitution says. And it is in their bosom to redirect it back to 99. They should have instructed that because we have an article in the Constitution that talks about someone leaving their party or not, we are redirecting it. It should go to the Supreme Court, and it should go to the High Court. And if the High Court also misinterprets the law, we would come in and reinterpret it and clear it. Did that happen? And it's created a lot of confusion. A lot of confusion. But you see, the good thing, the good thing is that this is happening at the tail end of the term of Parliament and of the governance process.
Meaning what?
Are we not at the tail end?
Yes, meaning what?
In terms of, can you imagine if this happened way earlier?
Like usually the 2 years that they tend to do the mid-term.
Do you know the kind of confusion it would have brought? Because please, when you were talking, I was quiet.
Oh, no, I'm not interrupting.
Yeah, you're interrupting me. You are. The Supreme Court.
I'm so sorry.
The Supreme Court, at the present moment.
So practically, you are saying that just in case, let's say the new parliament comes 2025.
Yes.
Then usually the parties in opposition, they usually elect their officers midterm, and by the end of the second year, third year, they've elected all their candidates and things like that, ideally, barring any delays. You are saying this could cause confusion?
If I decide that, okay, I'm in, and I decided that, no, yes, I came on the MPP ticket, I came on the NDC ticket, I came on the CPP ticket, but midterm, I'm not interested in them. Will the party sit and let them stay there? Do you think the party, Asiedun Ketia, will sit and let him stay there? You say, you don't want to be part of us again. Is that what you're saying? Then what are you sitting there for? But the Constitution said you came on the ticket of a party. And you have decided. You have shown the intention by deciding to go somewhere else. No, be so. Your Constitution, doesn't it say so? That you would what? What does your Constitution say? No, what is their Constitution? The MPP Constitution. Yes, read it for, read it for me.
Sabra, put it on the screen.
Read it for me. Read it for me. What does it say?
Sabra, put the MPP one.
So 39.
Yes, what does it say?
A member of the party, this MPP party,
Yes.
who stands as an independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party, or for an independent candidate, like I did for Lanche Martin, when the party has sponsored a candidate in a general election, by election, automatically forfeits his or her membership.
So this one, there's no point for negotiation to seek damages.
Automatically, this one, is it in the present or is it in the future? Or is it both?
Don't confuse us.
It's both. Automatic.
So then, go to the High Court.
Please.
Go to the High
Let me
Court.
finish.
All right. Please,
As far as
no, please, it's okay, it's okay. Let's conclude on this.
Master,
Conclude. Sorry, I begin one last round.
That is why I feel that the Supreme Court should have redirected back to the High Court and probably ordered Parliament to follow the principles in the Constitution and let the High Court decide whether they have exited their seat or not.
So I have this one from Nani Alsapon. He's a regular too. You know him.
He's my very good friend.
Okay. He says, ask the MPP lawyer, did Nano Hinin to, okay, that's for you. Boniface.
You let me have
and after that, okay. So now, what remedies are there now? What do we, I mean, practically, what does it mean, futuristically?
You see, first of all, Ghanaians need to understand the character of the MPP now. You understand? And need to understand that the Supreme Court, by this judgment, is helping perpetuate the new character of the MPP. The MPP right now is a threat to the rule of law. The MPP as it stands today is a threat to the rule of law.
You can't make those
Now,
statements.
why am I saying that? You see, we need to understand that the purpose of the Constitution we've taken upon ourselves is to guarantee us the rule of law. Now, one of the abiding principles of the rule of law is an abhorrence for arbitrariness. One is a support of the principle of the certainty of the law. That's one of the abiding principles of, and it's also against acts of capriciousness, so that the MPP, a major political institution, whose focus ought to be to build that right political culture that will sustain and guarantee for us the rule of law. And they are saying that in spite of their constitutional provision, which says that if you support an independent candidate, if you support any candidate apart from the candidate they are sponsoring, you understand, you automatically leave their party. They said they still reserve the right, in spite of this clear term of their constitution.
Automatic.
In terms of the clear automaticity, they still reserve the right to that when my brother Jantua has conducted himself in this manner, that would necessitate forfeiture. After him, there he will stay. If my learned friend and very good friend, senior, has done the only mistake that he went to a prime he should have contacted him. That's the only mistake he did. My very good friend. When he has conducted himself in this manner, after him there, they will sack him. Like they sacked Ohinto and Hubsadoye when Alan Chamata had not even become a candidate. They sacked them. That is an act that is capricious. That is an act that is arbitrary. That is an act that flies against everything we know and believe in as supporting or guaranteeing us the rule of law. Now, what the Supreme Court is saying is that they support that arbitrariness. Because the Supreme Court, when you read their judgment again, you go to page 27, and your people can go to page 27. You understand? And my brother here supports my position on that. Or when you go to page 27, I'm coming, when you go to page 27.
Please, you have 2 minutes, wrap up.
It says that, yes, it says an MP must vacate his seat if he leaves the party under which he was elected to join another party or become independent, and seeks to remain in parliament under their new political status. You understand? That is what they are saying. So this is the law. This law will necessitate a determination as to the membership of the MP currently. This because if he leaves the party, so there must be a question: has he left the party or not? That question must be determined. And I'm saying that the jurisdiction to determine this question does not lie with the Supreme Court. It does not. The determination of this question is a question of fact, which must be heard by the High Court. So the Supreme Court, after they've given this beautiful law, to go ahead and make a determination of that question, because that's what they did. Because they gave the release 1A, 1B, 1C, which in effect was to say that they have not left their parties as of today. But they do not have the jurisdiction to answer that question of fact. You understand? And that's why we are saying that, one, they put themselves in this big pit when they, in the first place, held that their jurisdiction had properly been invoked. Okay. You understand? Because then they put themselves in that pit. So what they should have done, please let me conclude on this. Okay. You understand? You gave me just 2 minutes in the earlier one. I have a lot of minutes outstanding. You see, what they should have done was to take the position the dissenting viewers took. Judges took. You understand? Allow the matter to go to the High Court. Simple. And per Article 131, this issue of interpretation will come up. Yeah. Then that issue will be referred to that. Then you limit yourself to just the interpretation. Then there'll be a burden on the High Court to then apply the interpretation as you have so given, because there's no way you can answer that question without determining whether or not they are still members of their party. You understand? Now, I want to implore all Ghanaians. When we say we have a responsibility to defend our constitution, we have a responsibility to defend the purpose of our constitution. Because the purpose of our constitution is to guarantee us the rule of law, because that's the only way where the aim and purpose and objectives of our constitution would be met. And those aims and objectives are to protect our lives, to protect our liberties, to protect our fundamental rights to pursue our own happiness. Now, when you have a political party that is acting in a manner that's inimical, adverse to the rule of law, then you must understand clearly that the MPP right now is a threat to national security. They are a threat to the rule of law. And we must do everything in our power to ensure that they do not retain power.
You are crying.
No, please.
Let us do that.
No, please.
You have jumped out.
No, please. The two of you, please. So practically now, what is the recourse to any party? I mean, individual or political parties or such organizations in such circumstances?
This ruling would create, if it has not started creating, confusion in the political parties. Because members of those parties would join political parties and ditch their party, but still remain in those parties. Now, in the past, people were afraid to lose their seats. So they didn't behave in a way that would let their parties expel them. Now, it's free for all. They will do it right in your face. You can't do them nothing.
No, what they call FOCO.
Can't do them FOCO. And that's why they say, shegelege. Can't do them FOCO. Can't do them FOCO. Now, the next thing too is that the MPP is actually behaving like owners of the country, and what doesn't suit them, they wouldn't accept and go to the Supreme Court and get endorsement.
What if the MPP is only, you know...
Why am I saying this? Why am I saying this?
Seeking a redress.
What am I saying this? The same MPP filed a motion to remove Adwoa Safo when Adwoa Safo was not conducting herself to their benefit. Everything's about their benefit, oh. Everything. So when you file that motion, not to the Supreme Court, to the Speaker, to declare that seat vacant, if the Speaker had declared it vacant, would you have gone to court? The answer is no, because at that time, it benefited them. That's what they want. So it's now like we are ruling. That is the whole thinking about this thing. That's it. My brother here was talking about divorce and referencing it to what we are talking about. You don't compare oranges and apples. In divorce, is there a law that says that if you file your divorce, you are deemed to have already exited the marriage? Is there a law like that? There's a law. There's a law which says that.
In the party.
Not in the party. The Constitution says that if he leaves the party of which he once was a member at the time of his election, at the time of his election, did he leave the party or not? Because I have told you here that he has left the party because you cannot pick a nomination form in any political party if you are not a member of that party. And I'm sure if the Supreme Court had taken time to allow Justice Eric Joe to, because he has been a political party man, he would have told them how you can be. Because let's say Sam George. Can Sam George just go to his constituency and to the MPP constituency and pick a form and say, I'm going to contest? Before he does that, the MPP will have satisfied itself that Sam George has now become our member, for God's sake. You see? So, this ruling is much ado about nothing, but because the Supreme Court and there has not been any reversal, we are bound to live by it. But I'm saying that this ruling will not stand the test of time.
So right now, are you going to seek amendment to your constitution in the next conference?
You see, before you get there, my friend Mr. Abaliba was saying that my another friend here is saying that it is a cacophony, the judgment is rendered as a cacophony, and there's going to be confusion in the parties. It's the same Supreme Court, presided over by His Lordship, there's that to go back, who in the Zanato case, all right, said that because the Higher Court had not referred the matter to the Supreme Court, all right, they are wrong. And he said here, listen, as the court, yes, yes, as because they were varying, they were no. You see, when you make your,
there's no comparison.
When you make your
submission.
What
is the comparison?
All right,
please allow you to make submission. Yeah.
Let those who are listening to us know whether it is true or not. Okay. Says as the court failed to do this here, as the court failed to do that, this court hereby so moto, that's so. And then it goes on to now determine the matter. It didn't go back to the High Court anymore. So this is not the only time that the Supreme Court would now look at the facts of the matter and make a determination to bring clarity and solve a problem.
Was that case in the Supreme Court already?
I asked a question.
Well, I'm saying that a matter was sent to the Supreme Court. By the analogy, when they gave the interpretation, you're saying that by necessary consequence of that, it must be reverted back to the High Court. And I'm saying the Supreme Court has not always done so. And the Supreme Court is guided by bringing clarity to a matter going forward. This is how, when this matter comes, this is how it is dealt with. Now, your matter about an internal party thing. Why is it that now we have my brother here, who I want back, and I'm still working on it. I'm still working on it for you to come back.
Of course, Captain.
I know, but
no return.
You will come back.
No return.
All right? And my brother Maliba here, and my senior brother here, happy birthday in advance. To now be so interested in MPP internal matters that they are now interpreting the constitution of MPP, which is subservient to a constitutional instrument, equally subservient to an act of parliament, let alone the constitution, and seeking to superimpose that upon the constitution. It doesn't even arise. Please, please,
No,
let
my question is premised.
let the party.
My
wait.
question is premised on how the judgments of the Supreme Court also
Yes.
affect other individual organizations and individuals
Exactly.
in relation to the actions they have to take thereof.
Right.
That is why.
Right. So let the party, okay, take the decisions they see appropriate. It could be that they won't take any action in respect of the Constitution. It could be that they will take action in respect of the Constitution. Let the party have a sober reflection
make that determination.
of how things are done. As I said, we are even, didn't you see the picture flying about Honorable Afenyo Makin and Honorable
Morrison.
Kene Japong with Cynthia Morrison? And then whatever we were seeking to do was scuttled because already the press took it out that, oh, she's agreed to come back. And you know, when we are in the processing, you already say that it scuttles it. All right? And so there are several discussions behind the scenes and several things that, as a party that thinks about the nation, Ghana, as a party that thinks about just one vote, because this election is so crucial that we just need one vote. The last time it was 23,000, isn't it? That determined this. Now we're 18,700,000 and something, and we need just one vote. And it's so crucial. So it's not for us to now be driving people away from us, and because we are not doing so, then someone will say there's double standardness and there's capriciousness. No, it is not, because we need you. I need your vote. You, Mr. Maliba. Then you said if some judge decides to come, we will so welcome him. We will so welcome him. Anyone. I'm not trivializing the issues. I'm not. Anyone who wants to join, and that's what we are doing. So we will not take steps that will drive people away, and that is not capricious.
It is not what the parties think the law is. So seeing Morrison, Afenyo Makin together doesn't mean that she has not left the party. It is the law that would, deal with your conduct and say that by so doing, so no amount of thousands of pictures. He can even go and snap pictures with Kufuor. That doesn't make her remain in the party. Did she cross or she has not crossed? The answer is that in that constituency, she's even campaigning against the MPP there.
But and the NDC is campaigning for her. Is that also?
But he says that they determined that. He says they.
How did they determine that?
I have seen
please
campaigning for Morris.
Conclude on this.
Conclude on this. I cannot go and pick a nomination form from the NDC without joining them. Impossible. They'll be the first people who pick up a phone and say, Janto, what are you doing? Are you part of our party? Cannot do that. Nor can I do that with the MPP. Nor can I do that with movement. The Supreme Court has made a decision. For me, what I want to happen, let sleeping dogs lie. There are important bills in Parliament that need to be passed before Parliament rises. And for me, one of the major bills that we all need to have consideration for is the temporary budget for handing over the first quarter. That is important. So, I plead with the Speaker. I will plead with the Speaker let's let sleeping dogs lie. The body language of the Supreme Court judges themselves, you saw that they looked a bit perturbed and fed up of what was going on. So let's let sleeping dogs lie. Let Parliament reopen. And NDC, I beg, you've made your point. You've made your point. Ghanaians who will support you will support you. Ghanaians who won't support you won't support you. Please, go back to your seats and let Parliament work. At least for the few days we have left for Parliament to sit. Because we were supposed to rise yesterday, wasn't it? November 14th, if I'm not mistaken. They would have to come back again when? After elections. And if elections go second round, would they be able to come back? They won't. Short time. So please, I would say, Parliament is an important institution in this country. Parliament is an institution that handles legislative laws for our country. And there are legislative laws that need to be passed and heard. So, I beg, Mr. Speaker, recall Parliament. And you see, the other thing that the political parties shouldn't do, they shouldn't now, and people shouldn't now walk into Parliament and be shouting, yeah, 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 yeah. It is not important.
Why not?
Why should it be? We've won against. That riles a lot of dissension. It riles a lot of dissension. If Speaker calls and he says, go sit your seat, let it go. For me, a hung Parliament, the sitting for me is not important. 137 plus 1. For me, it's neither here or there where you sit. If you had majority, maybe so. It's hung. And the NDC cannot call government business, can they? Even if they say they are majority, can they call government business? They can't.
All right.
So let's stop all this kerfuffle. It's gone through the process.
You said we should stop what?
All the kerfuffle.
Kerfuffle.
Yes, let's stop it and
Thank you
let's move forward.
Much. Thank you very much, gentlemen.
A very distinguished Englishman who uses such words.
Well, we're also going to bring you what Maha Beach Resort are calling the beachy tidings and sandy joy this Christmas. So they're telling you to book 2 nights and get the 3rd night free with all meals inclusive, starting from 6,000 Ghana cedis for a couple. So the package offering gets free access to all in-house facilities, swimming pools. That will be gym, cinema with popcorn, board games all available, snooker, and then entertainment. You also get to enjoy free airport pickups. That is when you arrive from Takrady on weekends. Fun activities will include tour of the beautiful facility they have with a golf cart, splash playground for kids, bouncy castles, trampolines, bicycle rides, quid bike rides, as well as boat rides to the famous Maha village. Jet skis also available, banana boats, party bus rides, nightclub with available live band, night DJs, and then also brass band all available. They also have a famous itinerary on the trip, which is a trip to Nzulezu, Fort Apollonia, Ankasa Forest, and then a memorial home of Dr. Kwame Nkrumah. So to ensure that you do this, make sure you book and pay before the 1st of December and enjoy that extra 10% discounts they have for this pricing. And then you can also call them for further reservations to avoid any disappointment through the number 030-3977-773 or 050-157-0684. You can also email them, sm@maharesort.com, or you can also get onto their social media handles as well as their website, maharesort.com, which is a paradise found under the palm trees till Christmas. A great one. I know the great rich lawyers around here will also take part as well. But we have cash out, and today is a mega jackpot. So we want to start off with some great insights where we're getting our first draw. 5,000 Ghana cedis going to be giving right. We'll call the lucky winner. Already over 50 people have enjoyed 200 Ghana cedis, and those ones we don't even announce those ones. So this one, the first one, we're incrementally going to increase this as well. 5,000 Ghana cedis to the number 02477881. Please make sure *439# choose an option 8 becomes the option for you, and then become a great winner this morning. We'll take a break. We'll be right back.